Hello again, and welcome to 3PB's Brunch at the end of May. You're going to hear today from me. My name's Stephen Abberley, and thereafterwards from Stephen Howard. I'm going to talk to you about confidential information in the context of Children Act proceedings, and Stephen is going to talk to you about intermediary assessment. When I was asked to think about what I might do for a brunch seminar, a case came to mind. And plainly, I've had to alter the facts a little bit, but I've put the essence of them up on the screen. I'll just tell you about them briefly. In a nutshell, a mother who comes from a nice middle-class family, professional parents, quite well-to-do, and a father who comes from a salt-of-the-earth background, but who nevertheless presents as though he comes from a very wealthy background, the sort of chap that can't help but look in the shop window when he walks past. The two of them have a relationship, and it's a relationship with no holds barred, and that includes sexually. So, and involves BDSM type practices and safe words and the like. Sometime into the relationship, mum becomes pregnant and they have a child. After the child's born, mother becomes not very well. Her mental health goes into decline, and father becomes quite worried about the way in which she's looking after their child. And so he does his best to help, but matters deteriorate and he is excluded by the mother from the child's life. So he brings a case for what was called a residence order, a lives with order under Section 8 of the Act, and that is responded to by the mother with a series of allegations of domestic abuse and of rape. And the allegations that she makes are accompanied with quite florid descriptions of things that she says he's done. Father remains on reasonable terms with the mother's family, and the mother's sister gets in touch with father and says, I've found some diaries of my sister and they contradict what she says about you. So I'm going to drop them off at your house. So really, that's the scenario that brought me to think about this particular issue. What do we do with this sort of information in the context of Children Act proceedings? So there we've got the last bit of the scenario. Starting point, Article 8, which we all know and can doubtless recite in our sleep. Everyone has the right for a private and family life. Don't need to spend very long on that. What does family life amount to? That case, a UK case, simply tells us what I expect we all know anyway, which is that family life is looked at broadly. It's not married with 2.5 children. Essentially, what you're looking for is a relationship where there has been some commitment, and that will bring a court into looking at a scenario as being concerned with family life. The bit of Article 8 that we probably don't always look at is the qualifying bit, Article 8.2. And that tells us that you can't interfere in somebody's private life except for in particular circumstances. I've highlighted the last bit of it. Given the scenario that I read out to you at the beginning of the talk, you can interfere in somebody's private life for the protection of the rights and freedoms of others. So we might want to bear that in mind in relation to the scenario. Of course, very often in a case where Article 8 is before the court, it's accompanied by Article 10 arguments. But for us, not very often in the context of private law proceedings or in public law care proceedings, because we're not talking about publishing material broadly outside of the proceedings. The only person who there is a question mark about whether they should see the material or not is the judge. And we could hardly bring that into the category of what's intended by freedom of expression. But the reason why it's relevant to this particular question is because there is, similarly with Article 8, a qualifying bit at Article 10.2, which says that you can interfere in somebody's right to free expression if you're doing that to protect the reputation or the rights of others, or to prevent disclosure of information that was received in confidence. Now, basically, the reason I raise that at this juncture is nowadays, the law in England and Wales in relation to information which is protected very much has to be compatible with the case law under Articles 8 and Articles 10 that comes from the Strasbourg Court. So if we think about information that falls under illegal information or information that's been obtained illegally, first thing we think about is, might there be a crime involved in obtaining this information? And I'm sure we all know, we ought to know, because we're all registered under the Act, about criminal offences under the Data Protection Act, and what happens if we inadvertently or intentionally do things with people's personal data which they wouldn't wish us to do. We could end up in a lot of trouble. So the next thing we have to think about is civil liability. And these days, if we think back to the law of torts, when I was taught the law of torts, this wasn't so relevant. But these days, no doubt when you're taught about tort at university, the starting point again is going to be Articles 8 and Articles 10 of the European Convention, because the way in which we define torts in this country now has to be compliant with the case law in relation to those articles. So from those articles, we get these types of information which are protected. There's a tort in English law of the misuse of private information. And of course, that stems from Article 8 of the Convention, or it's expressed in Article 8 terms these days. And the definition of it, the misuse of private information, you can find crystallized in this case of Campbell versus MGN by Lord Nichols. He tells you what it means and why it's necessary to have that tort to protect us and to give us a degree of privacy, which is essential in a democratic society. Otherwise, we're into the realms of an Orwellian society and all the problems that that brings. Some of us need to remember that actually when we get to the end of care proceedings and we consider the information we've had access to about the respondents in those proceedings. The test for private information is there a reasonable expectation of privacy or a reasonable person of ordinary sensibilities? So it's an objective test. So it's not down to somebody asserting privacy to say, well, I thought it was private, because the defendant or the court is entitled to say to them, I'm sorry, but that won't do. Most people wouldn't have thought that that was private information. So that's information that's protected. And if it's obtained unlawfully, then the court is going to be concerned about that. Next tort is a breach of confidence. And that's defined in the Attorney General and the Guardian newspapers quite a long time ago. And essentially the test there is, when the person receives that information, do they know, or ought they to reasonably, again, an objective test, reasonably appreciate that the information is confidential? It's been given to them in circumstances where they ought to know that it isn't to be shared. And examples of the sort of information that the courts will routinely regard as confidential are set out in that other case, Douglas versus Hello magazine from 2007. And there's about 10, 15 things there that are set out that if that's the sort of information that's in issue, the court's going to regard it as confidential information. And if somebody shares it, then they've committed a tortious act. And then, of course, something that we all ought to be familiar with, Section 98 of the Children Act, which tells us that nobody is allowed to publish anything in relation to the child in the proceedings that might identify the child or reasonably to be thought would run the risk of identifying the child. And the notable thing about this is the defence is one that shifts the burden onto the person who's published the material to show that they had no reason to suspect that it would identify the child, or they didn't know it was going to. So that's confidential information from within proceedings that can't be published outside of the proceedings. And of course, that's covered as well under the family procedure rules. And then, of course, I don't need to spend any time on this because we all know about legal professional privilege. Okay, so how do the courts treat this information when it becomes in issue in the case? I decided to have a look at the situation in relation to financial remedies because for a long time now, probably more in financial remedy cases than Children Act cases, there's been a desire on the part of some to snoop into the private affairs of their soon-to-be ex-partner because they think their ex-partner is trying to hoodwink the court by presenting themselves to be a much poorer person than in reality they are. And of course, that was the case in this case, the Immerman case, where the wife's brothers decided to hack into the husband's business computers in order to demonstrate that, as opposed to being a man of straw, which was the position he was presenting to the court, in fact, he was very, very wealthy. And so the wife turns up to court with all of this information, which she's obtained by breaching the security of her husband's systems, and her brother's potentially committing a criminal offence and certainly a tortious act because it's information that they ought to have realised was confidential information. What do you do with it as a consequence? Well, that case, the Immerman case, followed by this other case, Abberley, in 2016, which is Lady Justice McCurr in the Court of Appeal, says basically the solicitor, once they receive this information from the client, I'm going to use the one partner takes information pertaining to the other partner's private affairs to their solicitor. The solicitor is supposed to say, what's that? And then once they have it explained to them, they say, I don't want to see it. They put it in a sealed envelope, or if it's electronic material, they send it to the solicitor for the other party and say, here it is. We shouldn't have this. I'm sending it to you and I'm telling you that we don't have any copies of it. But it seems that in the context of financial remedy proceedings, the person who's obtained the material and has read it can say to the court in an affidavit, I've read this stuff and it relates to my other half's finances. And when he tells you he hasn't got any money, it's utter rubbish because this is what I've read and I'm going by my memory. And that affidavit then can then be considered by the court as to whether it's going to be admitted into evidence. So essentially what's happened in the context of financial remedy proceedings is before the court will consider looking at the information itself, we engage in this exercise of a memory test to see whether the person who shouldn't have looked at the information can remember what's in it sufficient to persuade the court of its relevance. There's the test in financial proceedings, and that comes from Immerman. And the important bit is the first bit in quotation marks, whether it's necessary for disposing fairly of the application for financial remedy now or for saving costs. So basically, the court looks to the word necessary, which we're all familiar with in a different context, to decide whether they ought to allow the information in, notwithstanding the fact that it was obtained in a way that was illegal or unlawful. Generally, in financial remedy cases, full and frank disclosure required. So an interesting question for you, does the process arrived at in the context of these proceedings really allow for uh, 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 an atmosphere, a discipline of full and frank disclosure. I suppose the difficulty is if you don't behave in this way, in fact, you're encouraging people to go off on a snooping expedition into their ex's financial affairs. If you look briefly at civil cases and as to what happens in those, there is a power under the CPR to exclude evidence which would otherwise be admissible. And of course, for this evidence to be admissible, it would have to be relevant to the issues before the court. It doesn't, the CPR doesn't tell the court that it's got to exclude the information because of the manner in which it was obtained. It just gives the court the power to exclude it. There's a case here, a fairly recent case, involving an insurance fraud where somebody hacks the computer of the other party to demonstrate that their claim is in fact fraudulent. The hacking was illegal, the obtaining of the information was unlawful, but ultimately the information was considered to be relevant and therefore admissible because it defeated the claim that was being made. In Children Act cases, we need to have a quick look at the rules. Of course, go to the family procedure rules and look first at the overriding objective, because if the court's going to address this issue, it's going to expect you to address that. There are general case management powers in Part 4 of the rules, which include the court's power to limit the sort of issues that are before the court and the evidence that goes to those issues. And then under FPR 22.1, specifically, the court has the power to exclude evidence. When one has a look in the red book in relation to that rule particularly, it cites the Immerman case. It doesn't cite any cases concerned with Children Act proceedings, be they private law or public law proceedings. So if we pull all of this together and go back to the scenario that I started with at the beginning of the case, in circumstances where it's necessary really to look at private law cases to think about this properly, because if we think about the care proceedings that we deal in, we pretty much end up with all sorts of information because the state is involved and lots of disclosure orders are made. Not the same in a private law context. One doesn't routinely get police disclosure. Costs are involved, proportionality judgments are involved. But in circumstances where in a private law case, this sort of information comes to light, first of all, if we think back to the scenario at the beginning, what is this information? How is it classified? Well, it's obvious, it's private information. The mother had a reasonable expectation that what she wrote in her diaries was going to be private. And so if the father seeks to use this information, is he misusing private information? Well, there's the interesting question. Is it a misuse in circumstances where Article 8 permits the court or the state to interfere with a person's private life if it is to protect the rights and the freedoms of others? And if we think about the mother's allegations against the father in this particular scenario, extremely serious allegations of violence and sexual assault, if the father isn't able to properly adduce evidence to contradict those assertions and findings are made to that extent, his rights and freedoms under Article 8 are severely curtailed. So if we think back to the domestic case law, is this a case in which the father is taking stuff to his solicitors, which they put in a sealed envelope, which goes back to the mother's solicitors unopened? Or is it in fact a scenario whereby the material finds its way into a statement or an affidavit which gets put before the court, and there is a proper argument as to whether the material ought to be admitted, accepting that it's private information, and therefore there is a potential for misuse of private information, either by the mother's sister and by the father, but in circumstances where the court ought to consider the information because it contradicts the mother's serious allegations. So hopefully, with that brief and breakneck speed tour through the relevant legal principles, we've been able to answer a difficult conundrum which otherwise doesn't readily appear in the case law. So thank you very much for listening, and I'm going to hand over to Stephen Howard now. Thanks.
Well, good morning, everybody. It's lovely to see quite so many of you have joined us today for this seminar. I'm going to just share my screen with you now so that you've got my slides, and you should now be seeing that I'm going to be addressing you just briefly on issues to do with cognitive assessments and intermediaries to give an update on where we currently are. My talk is going to focus on care proceedings. That's where I practice most of the time, but what I say has general application across all family proceedings in which there is a vulnerable party or litigant. So why does it matter? Well, there is an excellent talk that was given by the president of the family division to the Aspire conference in Exeter on the 7th of February 2023. I had the pleasure of seeing that speech being given by Sir Andrew. I had the misfortune of being the next speaker, which is always a very challenging act to follow. And it's a powerful speech that I would encourage everybody to have a read. It's available on the judiciary website. And what Sir Andrew does is he reminds everybody early on in his speech about a case that he did when he was in practice, in which a mother had managed to avoid, through masking, not on purpose, professionals working with her, identifying that she had an intellectual impairment. And that led to her not having the support and assistance that she really required, both after the birth of her child, the child suffered some injuries, and also during the initial stages of the proceedings. And those intellectual deficits came as quite a surprise, we're told by Sir Andrew, to the social work team that was involved, but also to that person's family who hadn't understood how limited that mother actually was. And it was only through a professional psychological assessment that the underlying situation was understood. The speech also sets out clearly the importance of intermediaries in relevant cases where a party, particularly in care proceedings, a parent, needs an intermediary to be able to engage properly in the proceedings and give best evidence. The talk was aimed at parents with learning disabilities. That was the subject of the conference. And it reminds us about relevant guidance as well, such as the 2018 report on working with adults with learning disabilities and definitions that arise from that. The other part of the talk that is well worth paying attention to is reminders that parenting with support is an important concept. A highlighted need in the 2020 Care Crisis Review for special attention to be given to parents with learning disabilities when you're looking at issues of Section 20 and consent being properly given. And the very important point that I'm sure everybody has, but that equal treatment is a fundamental human right, and that's enshrined in Articles 12 and 13 of the United Nations Conventions on the Rights of Persons with Disabilities. And that requires states to ensure equality before the law and effective access to justice. And that duty is imposed on local authorities and public bodies by Article 6 of the ECHR. The Equal Treatment Bench Book also it is worth looking at when it comes to the important and critical part that intermediaries can play, and that speech pulls out the relevant parts there, as well as pointing everybody towards the advocate's gateway. But the final part of Sir Andrew's talk is the message being sent to us all to be alert, and that there's no room for complacency in identifying those involved in the proceedings who do need additional assistance and who have some form of intellectual impairment that could affect their ability to parent and be assessed appropriately, to be given the support they need, but also to engage in the proceedings. So that the start and the context of this talk is we all need to be alert to that. But what do we do when we've identified that there is a person in the case, most likely our client, who has some form of limitation? That means that we are concerned about their cognitive functioning, their ability to process the information and understand it. Well, as everybody who practices regularly in this area knows, the go-to is to apply for a cognitive assessment. And we have recent cases that identify the way that these are now going to be dealt with, and how they're dealt with seems to be different across the country. Different courts have varying approaches, from those that require paper applications to those where you go in and say to the judge, I'm concerned about my client, I need a cognitive assessment, and it gets nodded straight through. The nodding through period looks as if it has ended, and the case that I would draw your attention to on that is West Northamptonshire Council under Mother and Another. That's 2024 EWHC 395 family. It's a case of Mrs. Justice Levens. And in that case, the application was made, and was said to have been made, on a belts and braces basis. That was reminded to us as not being the appropriate basis upon which to make an application. A cognitive assessment is an application for expert assessment, and it is made under Part 25 of the rules, and should accompany all of the information a judge would need in order to do that, and you're all familiar with Part 25. But what the West Northamptonshire case reminds us is that there must be proper evidence that explains why the case went beyond standard difficulties faced by many parents in care proceedings, and explaining why the parents' needs cannot properly be managed with the use of, for example, careful language from professionals, and professionals taking the time to explain matters. The test, this is an expert application, is that of necessity. Now, just before I move on, this is also a case that is well worth having regard to if you're appearing for a guardian. That's because Mrs. Justice Leven noted per curiam that if it is clear to a guardian and a child solicitor that an application before the court should be refused, they should make that clear rather than saying they're neutral on the application. That's paragraph 17 of the judgment, and reminds those appearing for guardians and children about the President's guidance in the road ahead on making cases smaller, and the important role that guardians have in care proceedings in ensuring the interests of the child are met by minimising delay. In this case, it was an application that was made on paper, but a few minutes before the hearing commenced, an email was sent by the mother's solicitor to the judge seeking to withdraw the application for cognitive assessment. The judge went on, however, to deal with the application, and we hence have this judgment. The background says that there was really nothing in the paperwork to suggest the mother suffered from cognitive impairment or significant communication difficulties. The judge had had a look for whether there was reference to special educational needs statement or having attended anything other than a mainstream school. All of that was missing. And the application had minimal evidence supporting it to say why the solicitor who'd made that application believed the mother required such an assessment. The statement really only went as far as generalizations, is what we're told, saying the mother was deemed vulnerable due to her age, her past experiences and mental health issues, and she's indicated, that is the mother, that she struggled with engaging within professional meetings and retaining information. And what Mrs. Justice Leven said is that it hardly needs stating that those three matters are exceedingly common in care proceedings, and in her ladyship's view did not, without further detail, begin to justify a psychological assessment, a cognitive assessment. Paragraph 10 is where you need to go if you want to see what definitely needs to be in your statements in support. And that says that you need to say why the case goes beyond the standard difficulties faced by many parents in care proceedings and why the needs cannot be properly managed through other professional approaches to the parents. It cannot simply be a nice to have report. And I've given you the quote there, if anybody needs it, rather than pulling it out of the judgment. What it goes on to remind us is that very many times a parent with cognitive issues will have been identified at school during previous local authority interventions, or indeed in pre-proceedings work, and that may be your source material when you're making your application. I'm sure everybody is familiar with the Advocates Gateway. If you're not, then I would encourage looking at the toolkits that the Advocates Gateway sets out, because if what Mrs. Justice Leven has set out is applied by judges up and down the country, then you can expect to be asked why it is that the adjustments and amendments that the Advocates Gateway assist us in thinking about could not be sufficient to meet the needs of this person without a cognitive assessment being needed. As I said, the test is necessity. Necessary means necessary. That's what we were told by the former president in V.H&L, and it remains the same. It has a meaning between indispensable on one hand, useful, reasonable, or desirable on the other, but has the connotation of the imperative. And that is the test we're reminded that should be applied to cognitive assessments, just as they would be to wider psychological assessment. And so in that case, Mrs. Justice Leven refused in any event the application for the cognitive assessment because having noted that it will often be the case that parents may struggle to absorb information or understand it, the court reminded everybody that it's for all professionals, including lawyers and judges, to bear closely in mind the need for simple language, avoiding jargon, and dealing with matters in the way that a litigant can understand, as set out in the Advocates Gateway, rather than in that case needing a cognitive assessment. Just before I move on, in fact, I would highlight it would seem to me that proper applications are needed for cognitive assessments, as they would be for other assessments. That, I think, comes through clearly from what Mrs. Justice Leven is saying, particularly about the evidence in support. And I just flag that because very often we are in situations where applications made orally for cognitive assessment with very little preparation at the door of court, and it would seem that that would need to stop. Now, why is it important? Part of the reason it's important to get a cognitive assessment in a case is because you may well need an intermediary or some other communication assistance for your vulnerable litigant. And there are two cases that I've put on the screen there that I'd want to draw your attention to, because again, while there's been divergence of practice around the country, in many courts, intermediaries are again nodded straight through. You have a cognitive assessment that says one would be beneficial, or you can demonstrate without a cognitive assessment that there is a vulnerability, and without saying anything else, you're given an intermediary. These two cases indicate that that approach really should stop and is not the way forward. Mr. Justice Williams, in the second of the two cases I put on the previous slide, reminds us of the important function that intermediaries can and do play within family proceedings in appropriate cases. but also reminds us that they're not to be used as a safety net or security blanket, either by lawyers or indeed the court, and their use should only be where necessary. Again, as you'll see when you read both of those cases, the test is necessity, but for a different reason to the test for cognitive assessments. And I'll come on to that in a moment. The reminder from Mrs. Justice Leven in another West Northamptonshire case, and you've got the citation here, to the Advocates Gateway, and also to the need for advocates to adapt to the witness and not the other way round, was said in the context of considering whether an intermediary was needed in that case. And the commonly encountered difficulties with litigants understanding court proceedings was said to be dealt with first and normally by the judge and the lawyers, ensuring simple language and breaks are taken so that understanding of what's happening can be provided, rather than needing to move on and have the formal intervention of an intermediary, the assistance of intermediary in the case. The West Northamptonshire case is of particular help because it draws together guidance that we've been lacking in the family court, because there is a paucity of guidance from the rules, and the criminal jurisdiction, the criminal courts, have rather greater body of guidance, and those have been pulled into the family court now by Mrs. Justice Leven, who identifies that there's no good reason for there to be a divergence of approach. An intermediary is defined within the rules in Rule 3A.1. And that definition is perhaps more limited than the role that we often see intermediaries use, because it deals with communicating questions to a witness or a party, or communicating to any person asking such questions the answer given by the witness or the party in reply, and explaining such questions or answers as is necessary to enable them to be understood by the witness or party or by the person asking such questions. Mr. Justice Williams notes that he wasn't addressed in his case on the more general proposition of the intermediaries attending the whole of hearings, but that is, in any event, the definition there within the rules. The criminal practice directions of 2015 give a lot more detail about consideration of when intermediaries can and should be appointed. And there is a body of case law in the criminal jurisdiction that is relevant. Now, at paragraph 45 of the judgment, Mrs. Justice Leven pulls out a number of propositions that she says can be extracted from the criminal jurisdiction and apply in the family jurisdiction. And those are that it will be exceptionally rare for an order for an intermediary to be appointed for a whole trial, and they are not to be appointed on a just-in-case basis. Her ladyship notes that in the family jurisdiction it appears to be common for intermediaries to be appointed for a whole trial, but in her ladyship's view it's clear that the court and the intermediary should consider very carefully whether that's justified. Second proposition, that the judge must give careful consideration not merely to the circumstances of the individual, but also to the facts and issues in the case, because those two parts of it interact with each other in deciding whether or not an intermediary is necessary. The intermediary should only be appointed if there are compelling reasons to do so, is the third proposition. Just pausing there, Mr. Justice Williams reminds us in his case that the test is necessity rather than compelling reasons. But with that amendment, that's the third proposition. Next, that the judge must have regard to whether there are other adaptations that will sufficiently meet the needs of the vulnerable party to ensure they can participate in the trial. The application must be considered carefully and with sensitivity, and a recommendation for an intermediary is not determinative. It's a matter for the judge. It would be unusual to adjourn if an intermediary has not been found once one has been said to be needed in a case, and there are steps that can ensure effective participation if no intermediary is in fact appointed. Mr. Justice Williams approves all that Mrs. Justice Leven has said in his subsequent case, which is the matter of a local authority in A and others. The intermediary's use is governed, as I've already said, by Rule 3A and PD 3AA, and that sets out when they can and should be appointed. The court has to have regard to the factors in Rule 3A.7 at A to M. There are relevant factors there that are going to apply in almost every case, but those factors look at whether there's perceived or actual intimidation. That may be the case in some of the care proceedings, but perhaps more commonly, whether the party or witness suffers from mental disorder or otherwise has a significant impairment of intelligence or social functioning, or a physical disability or suffers from a physical disorder or is undergoing medical treatment. Whether the matter is contentious, well, many care proceedings are. What questions the court is causing to be put to the witness, any characteristics that are relevant to the participation being made, and what measures are available to the court. That's not the entire list. There are others there. We're reminded by Mr. Justice Williams that the test again is necessity, but it's necessity arising from Rule 3A.2a sub 3 and onwards, because that says that a participation direction should be made where it's necessary to make the participation direction, and that's where the test of necessity is brought in. When looking at how the court considers applying the intermediary as a participation direction and whether that's necessary, Mr. Justice Williams takes us right back to the Advocate's Gateway and the vulnerable witness toolkits. And it's only in cases where the court is satisfied that a party or witness cannot give evidence, even with the adoption of all the other measures available, that the court will find it necessary to appoint an intermediary, is what Mr. Justice Williams. The evidence upon which you make your application, and I'm just going to pause here to remind everybody, these are not Part 25 applications, they're Part 18 applications for intermediaries. I do see very many Part 25 applications for them in some parts of the country, and that's simply not right. They are Part 18 applications. If you need any basis for that beyond what I've said there, have a look at this case of Mr. Justice Williams. He reminds you of that as well. But you need evidence to support your application, and that is going to come from either an intermediary report or other material available to you. And a cognitive assessment is a very common basis for that. That's why it's important to get your cognitive assessment application right, get it granted, get the information you need if you're for a vulnerable party. The application needs to set out clearly, in my view, why it is that the Advocate's Gateway and other measures would not meet the requirement of a fair trial being capable for that vulnerable litigant, and set that out clearly to assist your judge in applying this more rigorous test than many may be used to. Having decided whether an intermediary is going to be appointed, if one is, the court's going to go on to have a look at whether or not in making their judicial decision they are going to appoint intermediary for the whole trial or just for part of it, just for the questioning perhaps of that vulnerable witness. There's a spectrum, says Mr. Justice Williams quite reasonably, only towards the far end of the spectrum, where there'll be cases where an intermediary is necessary for the giving of evidence. It's a fairly high position. And it'll only be at the very far end, his lordship suggests, where there'll be cases where an intermediary is required for the whole of the hearing, and the very rarest of cases where the intermediary is likely to be necessary to give instructions ahead of the hearing. But ultimately, it's a case management decision that will be taken in the usual way, and it'll be a matter for the judge what they're going to do with that. So the long and the short of it is you can expect a more rigorous approach than perhaps you've experienced to date when dealing with cognitive assessments and intermediary assessments. And I hope that my talk has given you a whistle-stop tour of some of the factors you'll want to think about, some of the changes in practice you might want to implement to give your vulnerable party the best chance of getting the support they want, but also the cases that are best going to help you reference back to judges who will be applying them, how and why you're going to say you get the application through that you need. And thank you everybody for attending. I'm sorry we've run over 2 minutes our time slot. It's been a pleasure having you all today, and I hope that some of what we've said has been assistance to you within your practices and will help you going forward. Our next family brunch will be held on Thursday, the 27th of June. If you're able to come along to that, you will be given presentations by Laura Scott and Charles Hogan. Invitations will be sent out in due course in the usual way. I'm going to shamelessly plug that 3PB are holding our inaugural care conference in Southampton on Friday, the 6th of September. If you're interested in attending, you can book through our early bird ticket rate, which is available, and a booking link is being put in the chat box and will be sent to you in a follow-up email so that you've got information if you'd like to come to our care conference. Hope you have a fabulous rest of your day, that work isn't too bad, and look forward to seeing you at another family brunch relatively soon, I hope.